This program is brought to you by Emory University.
Welcome to the fourth biennial conference on transactional law and skills here at Emory. Thanks for coming. It's great to see all of you out there and to have Tina with us as well to kick us off today. I'm Sue Payne, the Executive Director of the Center for Transactional Law and Practice here. And just before we begin, I want to make sure that I do something important, and that is to thank just a few people. One is the key person who makes this conference tick. It's not me, it's Edna Patterson. And I don't see Edna here right now, but I hope she'll hear this or hear that I said it, and all the nice things that you have said about her, I will make sure to pass along. I also want to acknowledge and thank our sponsors of this conference, Bloomberg Law, LexisNexis, West Academic, and Wolters Kluwer. You don't realize how difficult it is to get sponsors until you're the one who has to ask. And I asked, and some people said no. So I'm very, very grateful to those who said yes. So I hope you'll visit their tables, their display tables today, and find out what new things they have to offer. Thank you very much. And I want to thank Transactions, the Tennessee Journal of Business Law, which will be publishing much of this in their special issue of the journal. Okay, that's all the sort of housekeeping stuff. I am so thrilled that you're all here and that we'll get to spend a few days talking about educating the transactional attorney of tomorrow. My favorite part about conferences like this is not necessarily the presentations, but because I'll go to many of those, but it's what happens in between the presentations when people are talking about what they're doing, and you can see the passion that people have for what they're doing at their various schools and firms. And I really relish knowing that a lot of that will go on today, and that many of you are so interested in developing and improving transactional law and skills education. It's energizing to be here, and I thank you all for that. And now, I have the great pleasure of introducing our kickoff speaker, Tina Stark. She was the first and founding director of Emory's Center for Transactional Law and Practice. Many of you know Tina as the author of the textbook used in your law school's contract drafting class. Here at Emory, you could say that Tina Stark is a household name. We've been using the first edition of her book from the beginning, and in the fall, we are going to be using the newest and second edition of her book, Drafting Contracts, How and Why Lawyers Do What They Do. And the students in our contract drafting classes frequently ask, what would Tina Stark do? I ask that too. And but as they're drafting their contracts, they curse her and they bless her as they turn to her textbook time and time again to find out what to do and how to do it. In 2008, I was sitting in the audience at Emory's first conference when Tina spoke about her fantasy transactional law curriculum. And I now look forward to hearing about Tina's new fantasies, as I know you do too. Please welcome our esteemed founding director, my mentor, and my friend, Tina Stark.
Well, I am very delighted to be back at Emory and delighted to see so many of you who've become friends and colleagues over the year. Frankly, this room is causing a bit of deja vu from the first conference in 2008, but that had a happy ending, so that's a fairly good memory. When Sue told me first that it was going to be in the faculty room, where I gave my job talk, I really was not so, that kind of deja vu. I mean, I got the job, but in any event. When I spoke at the first conference, I entitled my talk, "My Fantasy Curriculum and Other Almost Random Thoughts." And that title would work again today. But instead of proposing an integrated transactional skills curriculum, I'm proposing a wholesale revision of our first-year foundational curriculum, and one modeled on the veterinary medicine curriculum at the Cornell College of Veterinary Medicine. Now, were I entitling this talk in a proper academic fashion, I might have called it a thought experiment. I've learned something in my time at the Academy. But I've had good luck with my fantasies, at least two of them. First, Emory has embraced my fantasy curriculum. This year, its faculty taught 21 sections of contract drafting, the first course in the fantasy skills curriculum, and it expects to increase that number next year. So not bad for an elective course that didn't exist in 2007. Who would have thought? The second fantasy that came true, and the more important one, is that I married a really wonderful man 29 years ago, albeit it was at the age of 31. But I found him nonetheless. Now, I am assuming that because you are all lawyers, that none of you have the mathematical capacity to actually figure out my age. We will get to the issue of that at the end. That's going to be my other random thought, okay? So with that luck with my fantasies, I'm going to proceed with my new fantasy about the first-year educational curriculum. This fantasy had its genesis in December of last year when I attended my son Andy's white coat ceremony at Cornell Vet School. At this ceremony, the dean helps each student to don a white coat, the proper attire of a doctor. It's akin to a hooding ceremony at graduation, but it happens midway through the vet school 4 years. Being coated symbolizes the end of doctrinal education and the beginning of clinical education. Students recite the veterinarian's oath. It's a big deal. I cried. I also got permission from my son to show these photos. During the dean's speech elaborating on the symbolism of the coating ceremony, my mind started to do its thing. And I, of course, began to compare vet school to law school. For those of you who don't know anything about vet school, it's far harder to get into than law school. There are approximately 30 vet schools in the country, and all but a few of them are state schools. And the state schools generally admit 90% or more state residents. That's because they want to graduate those students, have them stay in state, and take care of their livestock. So that means that there are very few spots available for someone who's not living in a Midwest state that has a veterinary school. Now, because of that, getting into vet school is extremely competitive. It's more competitive than medical school. And once students get to vet school and matriculate, the work absolutely is inundating. The students use two graphic metaphors to describe the amount of knowledge that they have to assimilate. Right, and I press B, and next, okay. In the first, a fire hose blasts water right at their mouth. The mouth is the metaphorical brain, and the water coming at you is the knowledge that you're supposed to assimilate. A student, of course, cannot possibly swallow all that water, so she swallows as much as she can without drowning, and she definitely gags. The second metaphor is charming, funny, and apt. It begins with a student's brain being an iceberg. Each quantum of knowledge is a penguin, and only so many penguins can fit on the iceberg at any one time. Therefore, students have to push off certain penguins in order to make room for the new penguins. Now, to conceptualize the number of penguins, it really helps to keep in mind a favorite vet student's sarcasm. Real doctors treat more than one species. It was in thinking about all of this after the white coat, okay. After this, that I asked my son what for me was a pivotal question. His response will tell you everything. It's all in the tone. Most of you have children, and you can imagine the tone. So I said, Andy, how do you feel about learning about pigs and cows when what you really want to treat are dogs and cats? Now here's the key. Mom, my license will be to treat all animals. His answer prodded me to once again think about the legal curriculum, but this time in comparison to Cornell's vet school curriculum. I became curious. I began to troll the Cornell website with a disquieting regularity. How did Cornell teach all that medicine and all those skills about all those species in the same 4 years as medical school? And most importantly, were they any good at it? Now, in answer to the last question, I note, and this is with much trepidation, that U.S. News and World Report states that they're the #1 vet school in the country. You can do what you want with that information. At this juncture, I would like to thank Catherine Edmondson, who is Assistant Dean for Learning and Instruction at Cornell. I got serious about this way before Sue asked me to speak. I just wanted to know. So she spent significant time explaining to me the Cornell curriculum and its origins. And of course, all errors that follow are mine. As I said at the beginning of the talk, Cornell's curriculum first disrupted my relative equanimity at Andy's white coat ceremony when the dean was describing the significance. It symbolized a student's transition from studying the biomedical science to working with patients. In our argot, it signaled the shift from doctrine to practice. But the dean's description oversimplifies the Cornell curriculum and actually more accurately depicts what existed 25 years ago. In 1992, the Cornell faculty as a whole, can you imagine that kind of unanimity, reimagined its school's substantive curriculum and instructional methods. Now, the classic veterinary medicine sequence is very much like what you see at medical school. It's a sequence of lecture and lab courses, each course unrelated to the one before. So there's gross anatomy, I have to read this, gross anatomy, histology, and immunology, diagnostic imaging, and physiology. To the extent that these courses intersect, students have to figure that out on their own. In contrast, Cornell relies on interdisciplinary courses to teach students the foundation of veterinary medicine. They call these, of course, foundation courses, and they account for approximately 70% of the curriculum, and all the students take the same courses in the same order. Students and faculty colloquially refer to the foundation courses as blocks. That's because the curriculum allocates to each course a block of time that is unrelated to the semester. You could have a block that's 3 weeks, and you can have a block that goes into February. It all depends upon the content of the material and its complexity. So the material itself determines the length of the course. At Cornell, the first foundation block is the animal body. In this course, instead of studying histology and immunology, students study organs and body systems, and they do it using all the different scientific disciplines that are available. Therefore, their study of the heart will include gross anatomy and dissection, but students will also learn anatomy at the microscopic and ultrastructural level. Please don't ask. To add real-world context to the study of anatomy, the course ties together animal dissection with specific surgical procedures. The course also teaches developmental embryology, because how can students understand a malformation in an adult animal if it doesn't understand what happened during gestation? The pedagogic takeaway is that Cornell's foundation courses, this is their language, integrate diverse, intersecting disciplines, resulting early on in a deeper, more sophisticated understanding of basic science and disease. When Cornell reinvented its curriculum, it went beyond juggling the order and length of its courses. Students now also began to learn clinical skills immediately. And when I say immediately, I mean the first week. If during the first week when they were studying the animal body, they were studying the thorax, they learned how to physically examine the thorax. So everything stayed in context. And by the time they were done studying the animal body, they could give a physical exam. I would not have trusted my son to diagnose my dog, but he wasn't expected to have expertise. It was just the beginning of the iterative process that would lead to the expertise. In addition, as part of its new curriculum, Cornell also implemented multiple adult learning pedagogies. Its signature pedagogy is what's called the tutorial group. Each group has a small number of students and a tutor. The tutorial groups meet 3 times a week, each time for 2 hours. Each week, students use an actual hospital case as a learning exercise. The materials describe the animal's medical condition and its x-rays and its blood work. Students work in class collaboratively to try and diagnose the problem and to determine proper treatment. The tutorial format encourages active learning. The students are in charge. They lead the discussion. They ask the questions. The tutor only interjects to the extent necessary to advance the discussion. Whoever the tutor is, he or she, that person's job is not to answer questions. Instead, what happens is the students move the exercise along and they get to a certain point, and then they have a list of questions that they call learning issues. And before the next tutorial group, they have to research those learning issues. They can go to treatises, they can go on the web, they can work together. However they do it on their own. So the students are learning how to learn on their own. They're getting away from the teacher presenting the information on the plate, which many of our students seem to want us to do. So early on, the students are beginning to take responsibility for their own learning and begin to emulate a practitioner. This pedagogy fosters the development of students' communication skills and their ability to work together collaboratively, things we keep hearing about. But what's most important to the kids, and I count my kid as a kid, the discussion and analysis mimics what a veterinarian would have had to do. The students learn to problem solve and to think like vets. The tutor groups are designed to develop student expertise. The pedagogic process is iterative. Each week, students address a new exercise, more sophisticated than the week before. And each week, students practice thinking like a vet and become more like one. After learning about the Cornell Curriculum, I was both energized and disheartened. I was energized because I had found this professional school that used all these cutting-edge pedagogies that we read about, and in fact, graduated well-trained entry-level veterinarians. Just as an aside, they do not graduate practice-ready vets. The term they use is entry-level. I'm just going to leave that alone. I was also disheartened because as I thought about what was going on in the academy, what we're doing essentially is incremental. We'll add something to a course, we'll add a new course, but we have not yet boldly gone where no law school has gone before. There's been no wholesale kind of change. So here's where my fantasy begins. Somehow, without dissension, we agree that the Cornell Curriculum offers valuable insights into professional education, and we decide to implement a version tailored to law schools. The focus is not on the full 3 years, but on our first year's courses that we require and several second-year courses that are de facto requirements because students take them, BA, evidence. Presumably, we require the courses that we do in the first year for some reason other than tradition. Although the specific justification for each of these courses was beyond the research that I did for this, I have some thoughts. I suggest that the teaching of Civ Pro, contracts, and administrative law reflect our profession's 3 primary umbrella practice areas: litigation, transactions, and litigation regulatory law. Those are broad areas under which a lot of different practices might fall. The curriculum's inclusion of criminal law, torts, and property possibly reflect that these were topics that were historically a significant part of a lawyer's practice, but that's all supposition on my part. As to constitutional law, I think that's teaching that is a civic duty. At most law schools, professors teach their courses independently with very little cross-pollination. Were we to reconceive our first-year courses in the Cornell model, the salient question is, how could we create some synergies in subject matter and the teaching of skills? My suggestion is that we create 3 foundation modules, 1 module for each of the 3 umbrella practice areas: litigation, transactions, and legislation, and the leg reg. A module's content would determine its length, but the goal would be to complete all the modules by the end of the 3rd semester. Therefore, students would still have significant opportunities to take clinics, externships, and additional doctrinal courses. The litigation module would be composed of 4 courses. Civil procedure, to teach students when, where, and how a lawsuit may be brought. Evidence, to teach students what facts may be introduced to prove a cause of action. Motion practice, to teach students how to obtain rulings specific to their matter. And torts, because they are civil wrongs and perfect cannon fodder as an unending source of litigation and hypotheticals. Motion practice is obviously not a first-year course or a traditional second-year course that most students take, but is so much a part of modern practice that it seemed to me that it was a must-have expertise and made sense to include. You might be able to convince me otherwise. Existing first-year legal writing courses would buttress the litigation model by teaching research and the drafting of memos. In addition, students would learn interviewing skills and attend tutorial groups that would focus on the intersection of the doctrinal courses. The transaction module would include 3 doctrinal courses: contracts, property, and BA. Although BA is basically a second-year course, an entity's form may very well affect the substance of a transaction, and therefore I think it's appropriate for it to be part of the Transaction Foundation module. Students would learn contract drafting, but only after learning the appropriate doctrine. They would also learn transaction-specific skills. Again, there would be tutorial groups. I imagine this fact pattern. It's kind of a nightmare. A 25-year-old man and his 14-year-old brother ask you to represent them in the negotiation of a lease with the division of a corporation. The brothers recently inherited Blackacre from their father, who had leased the property to the division, but without memorializing the agreement. So we've got land, we've got no writing, we've got a 14-year-old kid without capacity, we've got siblings, can you represent both of them? You got an ethics issue, does the 14-year-old have capacity? The lease was to the division of a corporation, which arguably has no power to enter into the contract. Write the preamble. Right? So that would not be the first case that we would give students in the tutorial, but it's what we might move towards. And the ability of the students to go beyond issue spotting, to thinking about how to resolve the issues, to begin to think about problem solving. Okay. The final module would be the leg reg module. I have the least to say about that because I know the least about it. Its courses would include administrative law, con law, and criminal law. And of course, students would learn skills and participate in the tutorial group. Now, other than sounding very cool, why go to the bother of reimagining our curriculum in the Cornell model? I hope that one of the following reasons may persuade you that it's at least reasonable to think about it at this point theoretically. First, I believe that we have an obligation to teach students the core doctrine and skills for the practice of law. And if our first-year courses are what we deem the basics, then we should teach those courses as well as we possibly can. We are the students' employees, and they should expect no less from us. Second, each model would introduce students to a practice area, both its doctrine and basic skills. This introduction might be unnecessary in connection with litigation. Everybody watches TV and movies, and everybody's seen litigation. They have a picture in their mind. But so many of our students enter law school without any understanding of transactions or regulatory law. Exposing the students to these areas of law very early on in their career gives them the opportunity to decide whether it interests them so that they can then take more courses. Deciding in one's third year that transactional practice is your calling may well be too late to take needed doctrinal and skills courses. Third, each module teaches core knowledge and skills. Lawyers don't practice in silos. Litigators draft contracts. They're called settlement contracts. It would not be the worst thing in the world if they drafted them well. Fourth, these are practice-oriented modules, and they provide the appropriate context for skills training. I say this over and over again. I am not sure I'm getting any place with it. All skills are not made the same. Interviewing a plaintiff who has a story to tell based on a static set of facts that occurred in the past is different from interviewing a trademark licensor about to negotiate a license that could turn a small company into a major player. The formats suggested for asking the questions just don't work in the same way when you transfer them from a litigation context to a transactional context. Okay. I suggest that in planning the new curriculum, we could consider, I'm being very optimistic here, that we consider the order of the foundation modules. I think it would make sense to start with litigation, start with something familiar, it's always easier, and then move from the familiar to the unfamiliar. A couple of thoughts on pedagogy, moving quickly now. In my fantasy, professors would continue to teach using the Socratic method. It is law school signature pedagogy, but the Carnegie report suggests that we cut back and that its overuse is negatively affecting students. Therefore, in the fantasy, professors would teach using alternative pedagogies, contextualizing the subject matter whenever possible. For example, if the students are studying pleadings rather than reading cases, they can look at a treatise, they can look at exemplars, and then they can critique a complaint, for example, and determine that it does not allege fraud with enough specificity. Okay. Yeah. I'm going to, okay. That's basically the short version of the fantasy. Before I conclude, I have an almost random thought. All my keynotes have an almost random thought, something else that I've thought about that I somehow want to get in. As I mentioned, I spent a lot of time on the Cornell website, and while I was there, I noticed that the school required as a prerequisite to admission 6 hours of English composition. Impressive. So during my final conversation with Dean Edmondson last week, I told her that I was going to ask a foolish question. Why did a vet school require 6 credits of English composition? Her response was terse and pungent, and this is pretty as close as I could get to verbatim. Vets need to be able to organize and express their thoughts in a concise and logical way. If medical records are not clear, how can doctors take care of patients? What if a vet has to refer a patient? Without a cogent explanation of the patient's history and treatment, how can the referral vet treat her new patient? And finally, for the school to assess what students have learned, the students have to be able to express themselves in an exam. I ask you, and not rhetorically, how can it be that vet schools require English composition as a prerequisite and law schools don't? I will tell you that dental schools require English composition. Now, here's the fun part. This is from the website of a top 10 medical school. I'm giving it as much cover as possible, okay? This is the medical school. Students must have 1 year of critical writing. I kept trying to figure out what to highlight. 1 year of critical writing and thinking preparation in a course devoted specifically to expository writing skills. And students must write with clarity and style, persuasively. And they have to have credible thesis arguments. They have to approach evidence with probity. And they must use source material with rigorous attribution. No way that applies to lawyers. Okay, so same university, the law school, a top 10 law school. The faculty prescribes no fixed requirements. The school looks for thorough learning in a field rather than vocational training. I am going to go on record as favoring 6 credits of English composition as a prerequisite to admission to law school. And as to whether lawyers should have the math skills to determine my age, I leave that up to you. Thank you very much. Sue, do we have time for questions? We have 5 minutes. So first thing I want to do is I want to have a vote. How many of you favor a prerequisite of English composition for the admission to law school? George, let the record reflect near unanimity. Okay. Any questions about Cornell? I mean, it's a very interesting program. And last night, while I pulled the all-nighter to do this, I kept cutting and cutting. So I'm happy to answer any questions you have or how it might apply to law school. The real issue is the tutorial. I mean, where are the people going to come from? Adjuncts. I think the Academy has to accept that adjuncts and practitioners are going to have a permanent place. And I think we have to just learn how to deal with that by learning how to train and monitor them. You had a question. I'm slightly deaf, so can't walk and can't hear, so. The bar exam is different. For the bar exam, there are 20 subjects you have to know and memorize for tomorrow. These courses that we're talking about are courses that we deem to be the foundation. And so I think having a deeper understanding of them is appropriate. You're saying vet schools like that? Yeah, they have exams they have to take. The assessments at the vet school are very different from law school. They have assessments regularly, midterms, quarterlies, finals, and they take boards. And what most people don't realize about medicine is that people look up a lot of stuff. And what the vets need to do is to know enough to issue spot and to ask the questions and think how difficult it is. Their patient never answers the question of how do you feel and what's hurting, right? So their skills, the ability to give a physical exam, their ability to analyze and deduce and problem solve, those are as important as remembering all the little things. Other questions?
Problem solving.
Yes, I'm aware of it.
They do for first-year students during the winter study period, where they do break the students into teams and they give them problems. Does that come any closer to your criteria or approach?
Well, the Harvard problem-solving program is like a 3-week program, and they have 6 or 7 problems. So that is with respect to whatever problem set they create. But it is not a redistribution of the courses into related courses that draw synergy from each other. They are like the tutorials in that they focus on problem solving, but it is not a whole pedagogy. It's a 3-week program. I don't know as much as I might about that. It's a very good question. They have different kinds of professors. They have clinical professors. They have people who research. The difference is that they all teach. And what they did 25 years ago is they worked out what the collaborative curriculum would be. it is now in place. I mean, obviously they juggle it and they change it, but a lot of that very hard initial work is done. What's interesting is Yale Medical School is now adopting this kind of pedagogy. UCLA Davis Vet School is adopting it. And what I found out is that there is an association dealing with research on education that has a division devoted to professional education. And the medical schools, the vet schools, and the dental schools all have people who attend those programs and study adult learning and pedagogies there. I've not answered your question directly. I don't know anything about the money or anything like that.